Go to the 164 statement.
Yes, I have seen those statements. Statements in record.
How can you expect conviction in this case? For your satisfaction, trial should be permitted. Otherwise, how can you expect conviction in this case?
As your lordship suggested, at least that's 420 sustained, my lordship, if that were to be the, because it's
Even
very
that,
apparent.
see, 420, dishonest intention right from the beginning.
Yes.
If there was no effort from his side or the parent side to get married, get you both married, which failed later, then 420, 100%.
No, my lords, that's false. That's a factually false statement. There was no
164,
effort.
not your statement, not his statement. Come to 164, our victim statement only.
The parents and brother's statements.
3 years older to the boy, so they said.
No, they say after this incident of abortion, when our
whatever it is, the efforts were made to get married. If no effort is made and he walks away, then 420 attracts. Both the petitioner and the respondent are, petitioner and the complainant have indulged in acts which are consensual. Neither have lured the other. Therefore, if the acts are of consensus between the two, the breach of a promise of marriage would not become an offense under section 420 of the IPC, as the ingredients under section 415 is hardly met. Yes.
FIR is at page number 16, Lordship. The narration is that from 2013 they were in they were of same place and they were residing together along with their brother and they were in a relationship, and in 2017 she underwent an abortion, and in 2018 she lodged a complaint that he has not kept his promise of marriage. That is the facts of the entire facts of the case.
Yes.
And effort were made, but ultimately parents did not agree because of.
Yes, ma'am.
Yes, it's made to look as if it's been a consensual relationship from beginning, physically. Not so, my lords, because right from the beginning, the petitioner had an intention of, it's not a case of breach of promise at the outset. He, my lords, right from the beginning said, because they come from a small town, both together came from a village from Bidar district. They, right from the beginning, the consensus was given only on the condition that he would marry her. That relation is continued for 5 long years, from 2013 to 17, admitted. That's that's on record.
Yes, yes.
But the incident, which has led to the complaint, is that the abortion, which happens. He, says that if you about this thing, I will marry you. That, according to me, is the factor which has to be taken into consideration by this honorable court, which, according to me, continues the misconception of fact which I'm asserting was there right from the beginning. It's not that it happened only in 2018. This cannot be disconnected from the relationship which started in 2013. That's the limited submission notes I have, because everything else is in your lordships. But I would, because now what happens, my lords? He is married. She remains unmarried, aborts the child at his insistence that post that he will marry her. She's not let to bear the child also. And he is married and settled. She still today. In fact, she is now left, I'm told that she's left Bangalore and job and gone back to her village, where again, my lords, to live as a single lady with all this incidents. And this came to fore the villages when the incident of abortion happened. Till then, my lords, nothing was. Therefore, my lords, this is a case for trial, because there's enough material to show, my lords, that it's not one of those cases which is largely in these cases made to look like a consensual relation.
Not made. Go to the 164 statement.
Yes, I have seen those statements. Statements in record.
How can you expect conviction in this case? For your satisfaction, trial should be permitted. Otherwise, how can you expect conviction in this case?
That's what I'm saying.
See the latest judgment.
Please, no?
See the latest judgment.
Yeah, I have seen lots of judgments there.
No, Supreme Court has confirmed my order. In little more detail, it is written.
Yes.
Miss X versus Mr. A.
Yes. Well, that's why there's a thin line of difference that we could draw. So what is my submission, lords? This is not those facts which fall into those.
No, in fact, under BNS, it is a crime. False promise of marriage, if it's a crime. But we are under IPC still.
According to me, justice has to be given to this lady, because she's. In fact, I had a chat with her yesterday at this stage of life when he settled married.
Very difficult, man. 417 ಇದೆಯಾ?
420.
420
ಇದೆಯಾ?
420 is
ಅದನ್ನ ಸಸ್ಟೈನ್ ಮಾಡ್ಬೋದು.
Your Lordship, yes, already 5 years and the ingredients for of cheating, they say that the marriage talks were held and fathers did not agree, parents did not
Anyway,
agree.
you've cheated. ಅದ್ರಲ್ಲೇನ್ ಡೌಟೇ ಇಲ್ಲ.
Your Lordship, he is married and having a child.
So,
Ingredient of cheating, that false promise, the complaint doesn't make out ingredients of cheating.
hmm.
420, 376.
For 5 years they are in relationship and
That is 376, guys.
Lordship, that on a false promise.
376 ಆಯ್ತು.
In FIR and 164, both doesn't make out 417.
There are 376, 420 and 313 minutes.
313 is abortion. ಅದು ಇವ್ರೇನ್ ಮಾಡಿಲ್ಲ, ನೀವಾಗ ಮಾಡ್ಕೊಂಡು. No, as a force, see, that is 313 comes with forceful abortion.
That is what is my case, Milots.
Where?
What I've stated, Milots.
Forceful abortion by use of force.
What I'm trying to say here, Milots, that
313.
what was also,
Ingredients are in 312.
because what happens is we could probably dissect it in two set of incidents. One, what he says is 2013 to 17. Yes, even if I go a step ahead, we could accept that. But what happens the subsequent event when she was pregnant? He says, if you abort this, I will marry you definitely.
See, 3112 is what causing miscarriages. 313 is punishable for that. Whoever voluntarily causes miscarriage, so and so and so.
Numbers from
Be
2000
caused be in good faith for the purpose of so and so. Like good faith ಇರೋದೇ ಇಲ್ಲ. But
because from 2013 she was led to believe, Milots. This is what I say, but that there was a misconception of fact that she would end up the relationship in a legal sanctity and get married. That also, Milots, gets coupled with another incident in 2017 by abortion.
let's ಕಷ್ಟ ಮಾಡಿ.
As your Lordship suggested, at least that's 420 sustained, Milots, if that were to be the, because it's
Even
very
that it
apparent.
is, see, 420, dishonest intention right from the beginning.
Yes.
If there was no effort from his side or the parent side to get married, get you both married, which failed later, then 420,
For
100%.
No, Milots, that's false. That's a factually false statement. There was no
164,
effort.
not your statement,
It's
not his statement. Come to 164, our
I have
victim
said
statement
parents-
only.
the parents and brother's statements.
3 years older to the boy, so they said,
No,
you
they
know,
say after this incident of abortion, when our
whatever it is, the efforts were made to get married. If no effort is made and he walks away, then 420 attracts.
but effort was one-sided. I mean, it's not that whatever. It's not like both parents sat and like what your Lordship's judgment, which came up about 2 weeks back. There, Lords, in fact,
Lordship,
both
even-
sides' marriage was talks were held and wife had certain financial.
No, that is engagement.
Yes, they were engaged and to
Their
be married.
betrothal ceremony had taken
Yes,
place.
and they were to married and then it breaks. This is not a case where efforts were made by both the parties. This is what. And efforts were made so much more so because after the abortion, not when they were in relation between 13 to 17.
Hmm.
That's another fact. Because that is an incident.
Yeah, I'm bound by what I have written and what the Supreme Court has.
But I am only impressing upon the code that a distinction could be made because of the.
No, when BNS comes, we'll see. Because their distinction is permissible. Definitely permissible.
I'll wait.
No, I can't put this in BNS.
The prospect.
This is under IPC only. Yes. The petitioner is before this court calling in question proceedings in registered for offences punishable under section 376, 420 and 313 of the IPC. Facts in brief, heard so and so. Facts in brief germane are as follows. The petitioner is the sole accused, the second respondent, the complainant. The petitioner and the complainant are said to have had a relationship right from 2011 through 2017.
13.
13.
13,
13.
11 ಅಂತೆಲ್ಲ
13
ನೋಡ್ತೀನ?
to 17.
13.
2013 to 2017. When
2011 in a 164 statement.
ಅದನ್ನೇ ಹೇಳಿದ್ ನನ್ನ 13 ಅಂತ ಹೇಳಿದ್ದು.
ಅವ್ರದ್ದಿಲ್ಲ, ಅವ್ರದ್ದು.
2011, your statement from 2011 through 2011 through 2017, and they were staying under the same roof. Therefore, the complainant herself narrates that it was a live-in relationship for close to 6 years. A complaint comes to be registered by the second respondent on 9/3/2018, alleging that the petitioner has had sexual relationship with the petitioner has had sexual relationship with the complainant on the promise of marriage, which from the inception was false. He had no intention to get married, and therefore the complaint is registered for offences punishable under section 376, 420. The complaint further narrates that on the instructions of the petitioner, the complainant undertook abortion, and therefore section 313 for the offence of miscarriage of offence of voluntarily causing miscarriage is laid against the petitioner. The concerned court takes cognizance of the offence committal 3-2.
Committed.
The matter is committed to the Court of Session on 3/2/2022. Reject matter. Yes.
The charge is rejected.
So the petitioner files an application seeking his discharge from the proceedings, invoking section 227 of the CRPC in SC 1993 of 2018. That having been rejected has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the relationship between the two, both physical and otherwise, was consensual, as they were living in the same house, and therefore it was a live-in relationship for 6 years. The talks of marriage between the two also did take place, and the parents of the petitioner did not agree, as the complainant was 3 years older to the petitioner. This is what is borne in the statement, is what the learned counsel would submit, and seeks to place reliance upon plethora of judgments rendered by this court or by the apex court or this court, as the case would be, seeking quashment of the proceedings. The learned counsel, Srimati Poonam Patil, representing the complainant, would make a vehement effort to refute the submissions, contending that they were living under the same roof, but the entire period in which they were living under the same roof was on the pretext that he would get married to the complainant. Therefore, it was the physical relationship that the petitioner had throughout the 6 years was on account of the promise of marriage, which from the inception was false. No effort was made to get married, and above all, it was the petitioner who directed the complainant to get the child aborted. Only then he could get married. The learned counsel would submit that this is not a case of breach of promise of marriage, but would fall under the category false promise of marriage, and therefore it is a matter of trial for the petitioner to come out clean. The learned HCGP would toe the lines of the complainant in contending that the charge sheet is filed and the matter is pending before the Court of Session. It should be permitted to be taken to its logical conclusion, as it is for the petitioner to come out clean in the trial. I have given my so-and-so. The afore-narrated facts are not in dispute. The relationship between the two is a matter of record. The relationship floundering results in a complaint being registered for the aforesaid offences. Since the issue springs from the complaint, I deem it appropriate to notice the complaint, page 16 to 17. The complainant herself narrates that they were in the same house as a live-in couple for about 4 years, from 2013 to 2016, and they were in love. They were in love, and it is the case of the complainant that the petitioner has had physical escapades with the complainant, all on account of promise of marriage, which he has eventually breached. Therefore, it is eventually breached. Therefore, the complaint alleges that it was a false promise of marriage. The police, after investigation, filed a charge sheet. The summary of the charge sheet, as obtaining in column number 7, reads as follows, page 13, 14. Madam, Kavya, ಈ ಕಡೆ ಎಲ್ಲ ಕಾಲಮ್ 6 ಮುಂದುವರೆದಿದೆ ಎಲ್ಲ ಟೈಪ್ ಮಾಡ್ಬಿಡಿ. 7 ಮಾತ್ರ ಇಲ್ಲ. A perusal at the summary of the charge sheet or the complaint, as the case would be, is indicative of the fact that the petitioner and the complainant were in live-in relationship for about 6 years. The 6 years would come not from the complaint or from the summary of the charge sheet, but from the statement of the complainant herself. The complainant tenders her statement under section 164 before the concerned court on 15/3/2018. The statement is germane to be noticed. It reads as follows. Page 37-38. It is the case of the complainant in her statement that the petitioner and the complainant knew each other since 2011, and the friendship had flowered into a relationship from 2013 to 2017, as they were living in the same house as a live-in couple. Therefore, the statement of the complainant, therefore, if the complaint, the summary, if the complaint, the statement of the complainant and the summary of the charge sheet are read in juxtaposition to each other, what would unmistakably emerge is that that all that has happened between the complainant, petitioner and the complainant were all acts on consensus. If acts on consensus. The learned counsel for the respondent, as observed herein above, makes a Herculean effort to bring the issue on the issue of false promise of marriage only on the score that the petitioner, the complainant got the child aborted only on the direction of the complainant, of the petitioner, and therefore it should come within the ambit of false promise of marriage. The said submission is noted but only to be rejected, as the issue noted only to be rejected, as all these acts come within the same umbrella of the consensual acts between the petitioner and the respondent. Therefore, the offense under section 376 or the fact of abortion under section 313, as is alleged, are loosely laid against the petitioner, which could not have been. Permitting further proceedings to move on the offenses under section 376 and 313 would run foul of the judgment of the apex court in the case of Naim Ahmad versus State of so-and-so, reported in 2023, SEC Online SC, page 89, where the apex court, considering identical facts where the prosecutrix before the apex court had also become pregnant and the abortion had taken place on the direction of the accused therein. The apex court holds that would not be enough circumstance to haul the accused for an offense under section 376 of the IPC. The apex court further considers whether it amounts to cheating or otherwise. The issue would be that for all the 6 years, both the petitioner and the respondent are petitioner and the complainant have indulged in acts which are consensual. Neither have lured the other. Therefore, if the acts are of consensus between the two, the breach of a promise of marriage would not become an offense under section 420 of the IPC, as the ingredients under section 415 is hardly met. Section 415 mandates that the intention of cheating by the accused upon the victim should be present from the inception. The inception in the case at hand is consensus. If the inception is consensus, it cannot lead to cheating. More so in the light of the fact that all efforts were made by the accused to get the victim in marriage, but the parents of the accused have denied marriage on the ground that the victim was 3 years older than the accused. Therefore, the case cannot be brought under the quote-unquote false promise of marriage. It at best is a breach of promise of marriage. None of the submissions that the learned counsel for the second respondent complainant seeks to contend are acceptable in the light of the fact of the issue standing answered by the apex court in the aforesaid judgment. Allowed quashed.
Just one submission, Lords.
Yes, ma'am.
If accused petitioner never made an effort to get married, Lords, if your Lordship just
Wait,
observe.
statement 164 statement ಅಲ್ಲಿ ನಿಮ್ದೇ ಇದೆ.
Their
ಪೇರೆಂಟ್ಸ್ ಹೋಗಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರು, they have denied ಅಂತ.
petitioner does not make an effort is what is fine, sir. Your Lordships observe that.
Anyway, yes. That's why I've quoted the statement also. Because these matters, innocuous matters go to the Supreme Court.